Welcome to the New Frontier, where we attempt to add just another grain of information to the vast ocean of knowledge that is the internet, and especially politics and public policy on YouTube. When I first joined YouTube, I loved watching political commentary, but noticed that there was a hole in what was being covered. Actual political news or public policy reviews that help make our representative democracy work. How does a representative democracy give you freedom as if you were in a democracy? The only way it can work is if you know enough about legislation on House and Senate floors to actually give your congressman and senator and state representatives an opinion about that legislation so they can represent you and that opinion on the House floor. How do we do that? We get you informed on public policy, and today we're talking about one of the most controversial pieces of legislation, assisted dying or aid in dying legislation. It was especially hot back in 2015 and 2016 when 9 states made the practice legal leading up to the 2016 presidential election. Democrats and Republicans staked their ground on how they felt on aid in dying or assisted suicide bills. Specifically, Democrats strongly supported this policy and Republicans strongly opposed it, leading to most Republican states outright banning or making it illegal to assist in someone's death even if they had a terminal illness, where now the whole West Coast and most of New England has made it legal to assist in someone who is both competent and can consent and has terminal illness, to assist in their death to end their suffering. There are 2 sides to this legislation. First, the last state to pass an assisted suicide bill was actually Hawaii, and I believe the governor of Hawaii's opinion, his statement on the bill on the day of signing, really summarizes the pro-argument for assisted suicide or aid in dying legislation. And that statement was, "It is time for terminally ill, mentally competent Hawaii residents who are suffering to make their own end-of-life choices with dignity, grace, and peace." Really, assisted suicide, if you are for it, is about ending the suffering and giving people who are going to die dignity before their death, ending the resources they may take from their families and healthcare bills and costs, and to end the longevity of suffering that likely led up to this point and will continue until this person dies. Now, the flip side is there are many people against assisted suicide. They believe it leads to a slippery slope of not only allowing competent individuals, but eventually non-competent individuals to practice assisted suicide. They believe that it can lead towards undue influence of those who are terminally ill and leading them towards a path of death to cut back on healthcare costs and resources, which to many is unjust because they believe every life is of value and that we should be fighting to sustain someone's life even as it nears death. And we should not think of people as nearly a cost or resources. Many people who do not believe in utilitarian values or the cost that it is one person's utility to society do not believe in this form of treatment. Now, the opposition of assisted suicide is palliative care, largely authored by the Catholic Church. Palliative care is giving someone all of the resources they need to limit their suffering leading up to death. Many of times these are heavy drugs and sedatives that allow someone to not experience pain even in the most painful times leading up to their death. Palliative care is about treating someone and giving them comfort leading up to their death. So those that support palliative care generally do not support assisted suicide legislation, but those that support assisted suicide legislation many of times also want palliative care options available for those that are not ready to take their own lives but would rather seek the comfort leading up to death that palliative care can offer. Now, the reason we're talking about this today is that Connecticut recently, their Public Health Committee voted to raise a bill up into public hearing which could add this past assisted suicide bill that they heard in 2019 back to the legislative agenda for 2020. Even though this legislative session is especially short, just 3 months in Connecticut, and supposed to be focused on budget issues for the state, this could raise a very controversial issue up to the state house. And spark a new trend that will likely finish New England's complete legalization of assisted suicide, along with many other states. It would also not be surprising if assisted suicide lobby groups would channel their resources to this time and this place right now to pass legislation like this as we lead to a presidential election. Now, specifically, Connecticut House Bill 5898, an act concerning aid in dying for terminally ill patients, is meant to do a few things. First, it's meant to define aid in dying, what the practice would look like in Connecticut, and build out specific safeguards in place that, if legalized, would protect from slippery slopes that many people would quickly develop if a bill like this was passed. First, aid in dying is the phrase given to represent assisted suicide in this bill. It's defined as the medical practice of a physician prescribing medication to a qualified patient who is terminally ill, which medication a qualified patient may self-administer to bring about his or her death. How the drug should be administered was one of the most central controversial tenets of past assisted suicide legislation. You may remember the name Jack Kevorkian, or Dr. Death. He was extremely controversial in the 80s and 90s, building the Kevorkian death machine, which was one of the first self-administering pharmaceutical drug releases for those who wanted to take their own lives. After this machine, which was actually called the Thanatron, similar to the word Thanos, the Greek god now, used in Marvel movies to symbolize death. The Thanatron was used by two patients of Dr. Kevorkian's to end their own lives, and since then, how someone dies, whether or not self-administering drugs still should be considered murder by a doctor, is something that's been largely discussed. But the greater controversy now lies with whether or not someone can be competent to elect suicide. The real question is competency. Can someone be competent and suicidal at the same time? Well, you can be if you define your way out of legal competency. Now, legally, it is unlikely for someone to be both competent and suicidal because psychologists believe that having suicidal tendencies is related to mental disorders of some sort, maybe minor, mostly major. But if you define in law, in legislation, a new definition for competency, you can work around legal terms and law that's already in place, and that's what this bill does. Now, one thing you've noticed if you've been with this channel for a while, and will notice if you stick around, is that most public policy change occurs right on the first page, 2 or 3 of bills where definitions lie. Most changes are made in the definitions of public policy, and we see that here as well in the definition of competency in Section 1 of this House bill in Connecticut. The definition states that competent is the opinion of a patient's attending physician, consulting physician, psychiatrist or psychologist, or a court that a patient has the capacity to understand and acknowledge the nature and consequences of healthcare decisions, including the benefit and disadvantages of treatment, to make an informed decision and to communicate such decision to healthcare providers, including communicating through a person familiar with a patient's manner of communicating. Now, the bill also surprisingly defines palliative care. What I mentioned before was the opposition of this assisted suicide. And it states that palliative care is healthcare centered on seriously ill patients and such patients' families that optimizes a patient's quality of life by anticipating, preventing, and treating a patient's suffering throughout the continuum of a patient's terminal illness, addresses the physical, emotional, social, and spiritual needs of a patient, facilitates patient autonomy, patient access to information, and patient choice, and includes but is not limited to discussions between a patient and healthcare provider concerning a patient's goals for treatment and appropriate treatment options available to a patient, including hospice care and comprehensive pain and symptom management. I'm glad that this definition was broken down because now we have both the definitions for aid in dying or self-administering life-ending drugs and also palliative care, which is the option for these individuals seeking or likely seeking assisted suicide, that they do have another option, and that is pain management leading to death, along with spiritual, psychological, and physical, anything that can assist in the real calming of those processes of the body and dying, and also assistance of your family leading up to the dying process. But finally, the bill defines terminal illness, and this is very important as well to define who will be affected by this legislation. And that is anyone with a terminal illness has an incurable and irreversible medical condition that will cause death within 6 months. Now, the bill, using this definition and Section 1 of the legislation and Section 2's 5 steps to getting assisted suicide, creates a total of 7 steps to receiving assisted suicide. Now, I know that's a lot to break down, but I will break down the 7 steps now. First, you have to be within 6 months of your death according to your attending physician. After your attending physician makes a medical report that you will be dying within the next 6 months, you must make a request for assisted suicide or aid in dying procedures. At least 15 days after that first request, you must make a second request for assisted suicide. That break period is meant to give you time to make sure this is the decision you want. Section 2 also says that you must be an adult, which they define as 18 years or older, are competent, which is determined by your attending physician, and if you need further inquiry into someone or a patient's mental stability, a attending physician can require counseling that then becomes another step in the process. You must be a resident of Connecticut, have been determined by an attending physician to have a terminal illness with no cure, and have voluntarily expressed your wish to receive aid in dying treatment. Now, to my surprise, a subsection was also added preventing anyone from making this decision on behalf of a patient. Anyone, legal guardians, people with a power of attorney, the highest standards of making decisions for somebody legally will not apply for this bill. Only you, the competent individual suffering from a terminal illness and within 6 months of death, can make the decision. That's the first of many safeguards this bill puts in place. So really you could say the bill's broken into 3 parts, even though there are many sections to the legislation. The first part is the definitions that really make the policy change and legal changes necessary to make this practice okay legally. Section 2 of this bill defines the practice and the requirements to reach assisted suicide. And then the third longest section of the bill lays out safeguards to make sure this procedure is not taken advantage of. This includes the wait period that we mentioned before. Technically, even though the bill states 15 days, it would require 17 days to receive assisted suicide, a day to write an initial request, a full 15-day wait period, and then a final request for assisted suicide. There's also safeguards in place in sections 7 and 8 that if attending physician believes a patient suffers from depression or any psychological condition, they must go through mandatory counseling. There is also safeguards in place for doctors, specifically if anyone influences someone to go through assisted suicide, it would still be considered murder under the law. But for doctors, the bill creates an exception that says no person shall be subject to civil or criminal liability or professional disciplinary action, including but not limited to revocation of such person's professional license for participating in the provision of medication or related activities in good faith, compliance, and the provisions of Section 1 to 14 of this bill, inclusive of this act. And 2, being present at the time of a qualified patient self-administering medication dispensed or prescribed in aid in dying. What this means is that a doctor who both prescribes and or is present for your death could not be charged with murder unless they unduly influenced you to seek that treatment. Now, finally, there's a bit of an odd Section 12 in this bill, kind of put right into the middle of the legislation, that didn't seem to fit and was extremely odd, especially for where this bill may be passed in Connecticut, which is really the headquarters of all life insurance policies and life insurance companies in the United States. Section 12 states that assisted suicide would no longer be considered suicide under the legal definition and would still allow a person to receive a life insurance funding that they paid for, even if that life insurance plan requires that you die from a manner other than suicide. It also prevents life insurance companies from discriminating against someone who is seeking an aid in dying treatment. Now, this is strange because you would think someone could make quite a bit of a fortune by assisted suicide and also seeking a large life insurance policy right before that procedure is in place. There are some other sections that try to clarify this legislation, but generally I thought it was odd that this section and the next few sections were included in the bill at all. But it's something that I'm sure the committee, and if raised to the legislative agenda for 2020, legislators will continue to work out. I also think you should work out an opinion on this issue, whether it be the assisted suicide generally, or more specifically how life insurance or legal definitions of suicide should be impacted by these laws. And once you form an opinion, you should let your state representatives know. Specifically, your state representative in the Connecticut House of Representatives or wherever you preside, you should let them know because they affect legislation in your state. Many people want to hop up to federal legislators, but in states is where most change around assisted suicide is being made. So let your legislators know what you think about the law. Even if it's legal in your state, you can always push back through your legislator, and if the bill's not even represented on your state's legislative session or agenda this year, if you support it, you can push that it be added. All from reaching out to your state representative. It is their job to represent you, but they can only do that if you have opinions on issues like these. Alright guys, subscribe for more. I enjoy talking to you today.